Don't touch me.
Right now you're trespassing.
Don't touch me. Don't. Hey, get off of me. Get off of me. Get off of me. I'm going into my building.
Pay for this building.
Yeah, we pay for this building. That's right. We do pay for this building.
Step back.
I'm getting. Don't push me. Yo, what are you doing? Yeah. What are you pushing me for? What are you pushing me? You have the right to remain silent. Anything you can say can and will be used.
A man walked into a police station lobby in New York City with a camera. Not a back office, not a restricted hallway. The lobby, the part of the building you and I are allowed to stand in. And the NYPD arrested him for it twice. That man is Sean Paul Reyes. Nearly 1 million people follow his channel, Long Island Audit. And the case that started in that lobby has now climbed all the way to the highest court in the state of New York. Just days ago, that court heard arguments that could decide whether anyone in New York can legally record the police inside a public building. My name is George Graves. I'm a criminal defense attorney, and I've spent years on exactly this question: where your right to record ends and an officer's authority begins. Most of what you've heard about it is wrong, so here's what I'm going to show you. First, what New York's right to record law actually says, word for word, because it's stronger than the police want you to know. Second, how a trespassing charge in a lobby turned into a case in front of the state's top court. And third, the part nobody's talking about, what this is going to cost New York City taxpayers, win or lose. Watch what happens in this footage first.
Test this theory. I've heard a lot of you in the comment section giving me this advice to see.
Can't record in here. There's a sign right there that says members of the public are prohibited from audio recording. Please shut the audio recorder off.
Did I say it was on? I didn't say it was on.
Listen, let me see. You're recording.
Do you have do you have probable cause to search my property, sir?
What?
Do you have probable cause, a warrant to search my property?
Warrant?
Yeah. Do you have
What does that sign say? You have your phone out. It's facing me.
But does that mean that I'm recording?
Yeah, let my boss answer you.
I'm not. Who says that I'm recording?
I just want to make, like you said, I don't want you filming out there, okay,
yeah.
But it's prohibited to film.
But I never said I was filming outside to begin with.
Okay.
You made that assumption.
But again, you're holding a phone up as you're mimicking a recording. I'm just letting you know if you are recording, you're in violation, you're trespassing, and I'm just advising you, you're not allowed to record inside a police precinct.
But no one said I was recording.
I'm just saying, just please, okay? You cannot record inside a police precinct, okay? You're holding up a phone, mimicking as if you're recording.
But there's nothing illegal about that, Lieutenant.
There isn't. You're right. But if you are not allowed to film inside a police precinct, you could be subject to arrest for trespassing. Okay, so if you're recording inside a police precinct, you are subject to trespassing. You're subjected.
But do you have reasonable articulable suspicion?
Now let me tell you why that arrest is a problem. Because New York is not a state where the right to record is some vague idea you have to argue about. It's written into the law twice. In June of 2020, after the George Floyd protests, New York City passed the Right to Record Act. It's Section 14-189 of the city's administrative code. It says, in plain language, that a person may record police activity and keep that recording and the device it's on. And it gives you the right to sue the city if they violate it. And the state did the same thing. Civil Rights Law Section 79-P. Same idea, statewide. The right to record law enforcement and a cause of action when they stop you. So the NYPD had two separate laws, city and state, both saying the same thing. And their response was to put up signs in precinct lobbies that said no recording. Here's where it falls apart for them. The whole case turns on one narrow question. Does that law reach inside the lobby of a police station? The city says the lobby doesn't count. Reyes says a public lobby is exactly where it counts most.
Is there a problem with us recording in the precinct? Because we have the law right here that says that we are specifically allowed to record in the precinct. So this is the sign that they're always referring to. What do you think holds more weight, ladies and gentlemen? This sign, members of the public are prohibited from audio video recording or photography inside this facility, or the actual law? Let's find out. Hey, how you doing?
I'm gonna ask you to step out.
Can I please speak to a supervisor?
First, you're gonna have to step out.
I have a law right here. You want to take a look
You're
at
gonna
it?
have to step out for me.
Please don't touch me. Don't touch me.
Step out.
Don't touch me.
Alright, so
Don't
step out
touch.
the
Don't
facility.
touch me.
Alright, so step out the facility.
Don't touch me.
Right now you're trespassing.
Don't touch me. Don't
Right now
touch
you're
me.
trespassing.
Hey,
Everyone
get
needs to
off
step
of me.
out. All
Get
right, no
off of
problem.
me.
All
Get
right,
off
now
of
we
me.
can talk.
Get
Now
off
we
of
can
me.
talk outside.
Read the law that says I have the
All right,
right
we
to
can
do
talk
it.
outside. Now
You're a
we
law
can talk.
enforcement officer. Read the law. It fell over there.
You wanted to talk.
I'm going inside where I have the right to record. I do. I have the right to record.
All right, you're trespassing.
I'm not. Nope.
Leave and you refuse
I'm
to
not
leave.
trespassing.
Now
I'm
you're
not
Now you're
trespassing.
because you're outside. So
No,
let's
I'm not
talk.
trespassing in a building that I pay
All
for
right, so
either.
let's talk.
There was no reason. Why'd you put your hands on me
Because I
that
asked
way?
you to leave and you refuse to leave.
My paper is there. That doesn't mean you can put your hands on me.
Do me a favor, grab his paper.
Let me speak to a supervisor.
All right, no problem.
Let me speak to a
All
supervisor.
right, we got one for you.
This is ridiculous.
All right, it's ridiculous that you're not following.
Listen,
I asked him.
This is where it gets interesting because the courts have been wrestling with it for almost 2 years, and the way they've handled it tells you how serious it is. It started in federal court. The judge was Jessica Clarke in the Southern District of New York. And here's a detail most people miss. She actually rejected his First Amendment argument. She ruled that a police precinct lobby is what the law calls a non-public forum, a place where your speech rights are weaker. And I'll be straight with you. I think she got that part wrong. The idea that you check your First Amendment rights at the door of a public building, a building your tax dollars paid for, the one place a citizen goes to report a crime or file a complaint against an officer, that reasoning is exactly how a department walls itself off from the public it answers to. Reyes was right to push it. He just did something smarter than most people would have. He didn't bring one weapon to that fight, he brought two. Because what saved him was New York's own laws. She found Reyes was likely to win under the state and city right to record acts. That was enough. She issued an injunction ordering the NYPD to stop enforcing its no recording policy in precinct lobbies and to take the signs down. The city appealed to the Second Circuit. And the Second Circuit did something telling. They agreed Reyes was suffering irreparable harm, but they said the real question, whether that state law actually protects recording inside a precinct, was an unsettled question of New York law that they had no business answering for New York. So they sent it up. They certified the question to the New York Court of Appeals, the highest court in the state, and held their own decision until that court answers. That's not a small move. A federal appeals court stopping and asking the state's top court to settle the law first. That only happens when the stakes are real and the answer is going to bind everyone. And just days ago, that court heard the arguments. And here's the part that should make your blood run a little cold. Even after a federal judge ordered the NYPD to stop, even after the signs came down, they did it again. In early 2026, with that injunction still in place, officers threw Reyes out of a precinct for recording. So this is not ancient history. This is a department that got a direct order from a federal court and kept going. Watch.
hey, what's up guys? Long Island Audit here, back again with another video. Today we're at the NYPD's 47th precinct here in the Bronx, New York. We are here today not only to peacefully exercise our First Amendment right, but also our New York City and New York State statutory rights to record law enforcement in the course of their duty, to peacefully exercise those rights, and to promote transparency and accountability within our government, and to ensure that our public servants recognize our rights and treat us with respect. Let's get into it. This is the infamous sign, members of the public are prohibited from audio, video recording inside this facility. But if you can see here, we have different badges, things like that.
How you doing, sir? You
Hey,
can't
what's up?
record in a police facility. You can record outside if you want, if you would like.
What's your name and badge number, sir?
Officer Monell. One second, actually. Let me grab this.
Yeah, sure.
It's Officer Monell, field number 20475.
Okay, and you said what?
And you can't record in a police facility, but you can record from outside of the police precinct.
Why couldn't you record? Is that the law or
That is a rule of department policy.
department policy? Okay. No, I can definitely record.
From the outside, yes, correct?
No, I can record right here.
No, you can't.
Yes, I
I'm
can.
telling you, you can't.
No, I can, sir.
So if you don't get out, you will be arrested for trespass. So once again, please step
Excuse me,
out.
I don't want to get in your way. Yeah, no, I definitely can, Officer Morel. So you're under a federal court order. I'm not sure if your supervisor would know, the sergeant there. The NYPD is currently under federal court order. So that way I'm allowed to, by the Second Circuit Court of Appeals. It's a preliminary injunction. So I am 100%.
Now, let me make this practical because the question in this case is not really about one lobby. It's about where your camera is protected and where it isn't. And the line is not where most people think it is. Start with the easy one: a public sidewalk, a street, a park. If an officer is doing their job in public, you can record them. Every federal court to seriously look at this agrees. That part is settled. Now step inside a government building that's open to the public. The lobby of a police station, the counter where you file a report, a courthouse hallway. This is the gray zone, and it's exactly what the New York case is about. The city's argument is that the second you walk through that door, you've left the public street and entered their house, where they make the rules. Reyes argues the opposite. If the public is invited in, your rights walk in with you. And then there's the area where the city is clearly right. The squad room, the holding cells, the parts of the building the public cannot enter. Nobody is claiming a right to film there. So this case is really a fight over one specific place: the public lobby, the doorway between the street where you're protected and the back office where you're not. So what do you actually do if an officer tells you to stop recording or to leave or to hand over your phone? Here's how you stand on your rights without handing them an excuse. First, if you're lawfully in a public place, you do not have to stop recording, and you do not have to apologize for it. Under New York's law, that right is written down in black and white. You can say it out loud. I have a right to record under Civil Rights Law 79P. Keep the camera up. The one thing they can use against you is physical interference, so don't give it to them. Standing your ground and filming is protected. Blocking a doorway or shoving past an officer into a back room is not. Keep your feet planted, keep your hands visible, keep recording. That is the strongest position you can be in. Second, do not surrender your phone. Both the city and the state law say you keep custody of your recording and your device. An officer cannot lawfully take your phone just because you filmed them. If they grab it, they have just handed you a second violation on top of the first. Third, here's the part that should make you feel powerful, not powerless. When an officer crosses that line, the camera in your hand is the most dangerous thing in the room. For them, Reyes got arrested twice. And what happened? His charges were thrown out, and he walked into federal court and got a judge to order the entire NYPD to stand down. He didn't win by backing off. He won because he kept rolling, and that footage became the evidence that put the most powerful police department in the country on the defensive. Your recording is not just your protection, it's your leverage. Keep it rolling, get the badge numbers, and make them answer for it. So let's
A police station lobby that lacks the necessary characteristics of a public space, because they're open 24 hours a day for the most part. Anyone's free to come in and do what they want to do, free to leave. It sounds pretty public.
Individuals like Mr. Reyes to violate NYPD's ban on recording in police precinct lobbies? The answer is no.
What is the problem that the legislature was intending to address with the statute?
The legislature was intending to address the problem of civilians' lack of access to evidence of police misconduct. And police misconduct can take place in a precinct lobby just as it can on the streets. Just in February, Officer Karan McFadden was indicted by the Brooklyn District Attorney for an assault in a precinct lobby, the only evidence of which was a civilian recording him in that lobby.
If we don't want to rely on authority to impose property restrictions as a landowner, do you lose?
Why couldn't a police precinct lobby be a public area?
Maybe talk about what actually happens next. And then let's talk about the money, because that's the part the city does not want on a thumbnail. If Reyes wins, the Court of Appeals establishes as binding New York law that the right to record reaches into the public areas of every police station in the state. The case goes back to the Second Circuit. The injunction almost certainly stands. And the NYPD's no recording policy is dead. Not just for him, for everyone. If he loses, the state law ground collapses, and the fight moves back to the Constitution, where, and this matters, the Second Circuit has been far more cautious than other courts in the country, because everywhere else, this is close to settled. 4 federal appeals courts, the 1st, the 3rd, the 5th, and the 7th, have all recognized a clearly established right to record police in public. The Second Circuit, the one covering New York, has been the holdout. That's the whole reason this case is riding on a state statute instead of the First Amendment. Now the money. Let me be straight with you because I'm not going to hand you a fake number. This isn't a settlement case. Nobody is cutting Reyes a giant check tomorrow. But make no mistake about the exposure. This was an official policy, signs in every precinct by order of the department. That's Monell liability, named for a Supreme Court case from 1978, and it means the city itself is on the hook, not just one officer, and qualified immunity does not save them. And under federal civil rights law, when the city loses, it pays the plaintiff's attorney's fees on top of the damages. In a case fought through federal court, the Second Circuit, and the Court of Appeals, those fees alone run into the millions. Every person ever turned away or arrested for recording in a lobby under that policy has a claim. And we know what these cases are worth because cities have already paid. When Boston arrested one man for filming police on his phone, it paid him $170,000. One man, one phone. Comparable right-to-record cases against big city departments have settled anywhere from $15,000 to $200,000 a person. And when New York City wrongfully arrested a crowd of protesters a few years back, it paid them around $21,500 each. That one settlement came to roughly $10 million. So, do the math the city's lawyers are doing right now. 1, no recording sign in every precinct, in all 5 boroughs, for years. Every person waved off. Every camera shut down. Every arrest like the 2 that happened to Reyes. You are not looking at one check. You are looking at a number with a lot of zeros and a class of plaintiffs that could fill a courtroom. The city knows it. That is the real reason they are burning through legal fees to fight a man over where he can point a camera. They are not protecting a precinct lobby. They are trying to keep the lid on a bill that gets bigger every single day that policy is on the books. This was never about one camera in one lobby. It's about the bill. And the bill is enormous. So here's where it stands. The highest court in New York is holding the answer to a question that sounds small and isn't. Can you record the police inside a public building? One man with a camera and a trespassing charge forced that question all the way to the top, and the ruling is going to land on every precinct in the state. I'll be watching for the decision, and when it comes down, I'll break down exactly what it means for you. If you want to be here for that, subscribe. I'm George Graves. Know your rights.